And may I at the same time hand up a chronology in regard to McCarthy, which I would want to take the court through in due course. I'm mindful of the time and that there are people who have to come after me, but I will endeavour to finish by tea. The court will recall that yesterday I mentioned this case which went to the House of Lords, and I want to draw attention to the similarities and to the test applied in this case. If I can just encapsulate the facts, there was an arms deal between the United Kingdom and Saudi Arabia, and the Serious Fraud Office started to investigate allegations of corruption and bribery in respect of that deal, and that a public officer abroad had been paid a bribe. And in the results, if I could ask you to turn to page 573 of the reported judgment. At the bottom, next to paragraph 11, the following is stated: the Al-Yamama investigation did continue, and in the autumn of 2006, the SFO, which is the Serious Fraud Office, intended to investigate certain bank accounts in Switzerland to ascertain whether payments had been made to an agent or public official of Saudi Arabia. The SFO had obtained the cooperation of the Swiss authorities. The attempt to gain access to Swiss bank information provoked an explicit threat by the Saudi authorities that if the Al-Yamama investigation were continued, Saudi Arabia would withdraw from the existing bilateral counter-terrorism cooperation arrangements with the UK, withdraw cooperation from the United Kingdom in relation to its strategic objectives in the Middle East, and end the negotiations then in train for the procurement of Typhoon aircraft. The Director of Prosecutions had to then decide, does he succumb to this threat or does he continue with the investigation? And at page 576, you will see what the Director of Prosecutions did, and the similarity to this case will become apparent. At paragraph 22, the Director discussed the matter further with his case team that evening. On the morning of 14 December, he confirmed to the Legal Secretary that his conclusion remained the same, that in his view, continuing the Al-Yamama investigation would risk serious harm to the UK's national and international security. He accordingly decided that the Al-Yamama investigation should be discontinued. His decision was announced in a press release the same day. It read, "The Director of the Serious Fraud Office has decided to discontinue the investigation into the affairs of BAE Systems plc as far as they relate to the Al-Yamama defence contract with the government of Saudi Arabia. This decision has been taken following representations that have been made both to the Attorney General and the Director of the SFO concerning the need to safeguard national and international security. It has been necessary to balance the need to maintain the rule of law against the wider public interest. No weight has been given to commercial interests or to the national economic interest." So there were suggestions that if he did not stop the prosecution and Saudi Arabia withdrew, that that British citizens may lose their lives. That was the perception. Now, it went to the High Court, and the High Court said that he must continue the prosecution, and the House of Lords overruled that. This is what happened. At page 580 is the main issue. It is common ground, paragraph 30, it is common ground in these proceedings that the Director is a public official appointed by the Crown, but independent of it. He is entrusted by Parliament with discretionary powers to investigate suspected offences which reasonably appear to him to involve serious or complex fraud, and to prosecute in such cases. These are powers given to him by Parliament as head of an independent professional service who is subject only to the superintendence of the Attorney General. There is an obvious analogy with the position of the Director of Public Prosecutions. It is accepted that the decisions of the Director are not immune from review by the courts, but authority makes plain that only in highly exceptional cases will the court disturb the decisions of an independent prosecutor. At page 581, against the letter G, towards the bottom, the court said the Attorney General on 13 December 2006 was said to be extremely unhappy at the implications of dropping the investigation at that stage. What determined the decision was the director's judgment that the public interest in saving British lives outweighed the public interest in pursuing BAE to conviction. And then finally, at page 584, the court said, the director was confronted by an ugly and obviously unwelcome threat. He had to decide what, if anything, he should do. He did not surrender his discretionary power of discretion to any third party, although he did consult the most expert source available to him in the person of the ambassador, and he did, as he was entitled, if not bound to do, consult the Attorney General, who was, however, properly left the decision to him. The issue in these proceedings is not whether his decision was right or wrong, nor whether the Divisional Court of the House agrees with it, but whether it was a decision which the director was lawfully entitled to take. Such an approach involves no affront to the rule of law, to which the principles of judicial review give effect. And we rely precisely on that this is his discretion, that is the national director, and unless there are allegations of that he was malafide, or that he had an ulterior motive, or that he didn't apply his mind, then his discretion stands, and the court should not impose its own wisdom on what the court would have done or what the court believes was reasonable. And yesterday, our learned friends referred to the...
Must be rational.
Must always be rational.
Pardon?
Must always be rational.
Yes.
But even being unreasonable is not irrational, because one can imagine that in the Corner House case, the House of Lords decision, one can imagine that there were many people in the United Kingdom who are upset that their prosecuting authority succumbed to a threat of this sort. And there were diverse views. But at the end of the day, and it may be that the majority of the people would not have taken the decision which the director of the Serious Fraud Office took. Maybe they would not have. But it was his discretion, and the House of Lords said it should not be interfered with. And yesterday, a learned friend referred to the two-stage test. Firstly, was there an abuse? And secondly, was the nature of such a character that it is sufficiently linked to justify a stay of prosecution? Now, he referred to the Latif case, again in the United Kingdom. And I just want to read from the case which they rely upon. It's in the bundle which they handed up to the court yesterday. It's at page 157. Now, I don't want to read the entire portion to the court because, with respect to your ladyship and your lordships can read it yourself. So if I skip anything, it's only because I understand that it will ultimately be read in full by the court. But starting at page 157, this is what the court said. The court may recall that this was an entrapment case. And during the case, the accused applied for a stay on the basis that there had been an entrapment. And it was refused, and they went on appeal. This is the appeal. In the middle of the page 157, it's page 360 of the judgment, the Court of Appeal rejected the concession of the prosecution and held that the customs officer did not commit an offence under Section 170 because he did not act fraudulently. Then the next paragraph. It is now necessary to consider the legal framework in which the issue of abuse of process must be considered. The starting point is that entrapment is not a defence under English law. This, however, is not the end of the matter. Towards the bottom, but 6 lines from the bottom, if the court always refuses to say such proceedings, the perception will be that the court condones criminal conduct and malpractice by law enforcement agencies. That would undermine public confidence in the criminal justice system and bring it into disrepute. On the other hand, if the court were always to stay proceedings in such cases, it would incur the reproach that it is failing to protect the public from serious crime. The weakness of both extreme positions leaves only one principled solution. The court has the discretion. It has to perform a balancing exercise. And in our case, that was the discretion given to the national director. He had to perform a balancing exercise. And over the page, in the middle, just between the letters B and C, Bennett was a case where a stay was appropriate because the defendant had been forcibly abducted and brought to this country to face trial in disregard of extradition laws. The speeches in Bennett conclusively established that proceedings may be stayed in the exercise of the judge's discretion, not only where a fair trial is impossible, but also where it would be contrary to the public interest in the integrity of the criminal justice system that a trial should take place. An infinite variety of cases could arise. General guidance as to how the discretion should be exercised in particular circumstances will not be useful. But it is possible to say that in a case such as the present, the judge must weigh in the balance the public interest in ensuring that those that are charged with grave crime should be tried, and the competing public interest in not conveying the impression that the court will adopt the reproach that the end justifies the means. So, yes, and I'll just point out that in the reasons of Mshila, which I'll come to, that's what he referred to. That's what he relied upon, what I've just read to the court. So I want to move on then to what was the problem? What was it that McCarthy was doing? What was his role? And I've handed up just a chronology to make this portion of the argument more speedy. There are references to the affidavits. Only in some instances will I need to refer to the affidavits themselves. The chronology is this. On the 1st of November 2007, that's when Dana was present at the meeting between Mshila, the deputies, and McCarthy. And the meeting decided that the decision to prosecute President Zuma should be left to the head of the DSO and the investigating director. If it need be said, he was not the president at that stage. On the 12th of November, Mshila met with his deputies to discuss the prosecution of the third respondent, that's President Zuma. The meeting resolved that McCarthy, together with Ramaiti and Hofmeyr, would meet with the prosecution team to review the case file. Mshila made it clear that it is up to McCarthy to take a final decision to prosecute, and we've referred to where this appears in the affidavits, and where the court will see Annexure WH53, Vili, legal position, NDPP not to make decision. Is NDPP comfortable with the decision? Decision of DSO, that was McCarthy, and NDPP comfortable. That was a note made in the minutes of that meeting, which appears at WH53 at page 373. On the 17th of November, Dana was instructed by McCarthy to finalize the indictment and to include Ngwengwe, he was the investigating director at the DSO, to include him in any future discussions. This is reinforced in Dana's notes. I needn't go there. In November 2007, McCarthy knew that suggestions to delay the prosecution would be rejected. He started lobbying individuals to postpone the prosecution. On the 21st of November, McCarthy tried to persuade Hofmeyr to delay the prosecution. Now, can I ask you to have regard to the answering affidavit at paragraph 164? It's at page... in volume 3 at page 214. This is what Hofmeyr said in his affidavit, and for purposes of this application, it must be accepted. It was around, it's 164, it was around that time that McCarthy first raised with me the possibility of postponing the prosecution in both the Zuma and Salibi cases. He did it informally, as was his style.
Just a minute, my page 214.
214, paragraph 164.
My paragraph
It's on 217.
217.
217. Paragraph 164 is on 217.
Yes.
Thank you. Somebody's then paginated mine.
That's how we have it here.
Okay.
That is. Hofmeyr says, it was around that time that McCarthy first raised with me the possibility of postponing the prosecution in both the President Zuma and Salibi cases. He did it informally, as was his style. McCarthy tried to persuade me that it was prudent for the NPA to delay the third respondent's prosecution. He also said that he did not believe that the NPA had much of a case against Salibi. I disagreed with him. He told me that it was our duty as senior public servants to assist President Mbeki. In other words, we should do everything we could to ensure that President Mbeki was successful at Polokwane. I objected and our conversation became heated. I told McCarthy that it was our duty in the NPA to remain independent. The nature of our work meant that we sometimes had to take decisions that impacted on senior politicians. We could not allow the NPA to be used as a political instrument. I've been active in the ANC and the United Democratic Front for many years before I joined the NPA. The one thing I know is that in politics, the wheel can turn very quickly. Those in power today can easily find themselves out of favour suddenly. I told McCarthy that it would be unconscionable for us to risk the future and independence of the NPA by coming embroiled in factional battles with political parties. I realised then that McCarthy was committed to supporting President Mbeki, whatever the cost to the NPA. Our relationship remained strained after that encounter. I later learned that he had successfully lobbied Mshila and persuaded him that it was necessary to delay the prosecution. If I can go back to our chronology, on the 27th of November, that's when Mshila and the deputies met. There was a briefing by the prosecution team. McCarthy was present, and all were satisfied the prosecution could go ahead. Can I just pause there for a moment? I see that I've overlooked something I wanted to raise, and that is in regard to what I've just read concerning Hofmeyr and McCarthy and their interaction. Again, just to show the court what it was that McCarthy was doing and how he was using his own political agenda and how he was using the NPA as an instrument to achieve his own political agenda. Can I ask the court to refer to just bear with me for a moment. Where's 9148? Volume 10. Volume 10 at page 908. And this is Hully's affidavit, and the document at 908, it's MH7. Is an attachment. It's J. It's MH7, page 908. May I proceed? This document at 908 is the special report of the Joint Standing Committee on Intelligence on the Special Browse Mole report. If I may ask you to return to page 914, 914 at the bottom. It's got, now this is 27 November 2007. You see the date at the bottom. At the same time that all of this was happening. Now come the findings of the JSCI, which says at the very last line, with all the relevant information at the disposal of the JSCI, we came to the following findings. The first one is, the Browse-Moll report is the product of the DSO. The leadership of the DSO, that's of course McCarthy, particularly the head, authorized the investigation and the production of this intelligence document, which was outside Section 28 of the NPA Act. Accordingly, the production of the Browse-Moll report was illegal. 2. The purpose of the instruction to compile the Browse-Moll report was primarily directed and targeted at gathering information on a known individual. This person was the Deputy President of the ANC, Jacob Zuma. And at paragraph 7, the DSO did not take any remedial or corrective actions after the leak of the Browse-Moll report, despite it being classified as a top secret document. They did not take any action against the senior special investigator from whom the leak originated. They neglected to take action against the illegal activities of those who were involved in the production of the Browse-Moll report. And finally, under recommendations, the executive authority must take appropriate action against the head of the DSO, again McCarthy, and all the officials who were involved in the production of the Browse-Moll report. Now, that was the report of the Joint Standing Committee who made these findings about what it was that McCarthy was up to
But
at
this
that
was
time.
already, this was then already available on the 27th of November
Yes, it was.
2007,
Yes, it
months before
About,
the decision was taken to stop the...
yes, about 3-4 months before.
Yes. And so what I'm actually getting at, Mr. Mshila at that stage knew about this report and what the findings were.
One assumes he must have been, because he was appointed in September. This is November, and if action must be taken, I would imagine that it is directed to him to take that action.
Was an action taken against McCarthy by Mr. Mshila? Papers.
I'm not sure if it's in the papers. I think the papers say. I'm not sure. I think the papers say no action was taken.
Yes.
On the 3rd of December, McCarthy went to see Mshila and said that he wanted to talk about postponing the President Zuma prosecution. Mshila did not agree with McCarthy that the prosecution should be postponed. He nevertheless accepted that McCarthy had the authority to make the decision. Mshila spoke to Down and told him there was a possibility that the prosecution of the President Zuma would only take place the following year. That's 4 December and 6 December. We know that Mshila phoned Down and told him he had decided to delay the prosecution, and we went through that yesterday, what his reasons were why he did that, which appears in his supplementary affidavit. The Dana affidavit in volume 33 is relevant in one or two respects. If I could ask the court to refer to volume 33 at paragraph 4. The Dana affidavit starts at page 3166. Paragraph 4, Dana says, I've read the answering affidavit of William Andrew Hofmeyer. I understand that Hofmeyer's affidavit has already been served and that it is intended that this affidavit will be served subsequently, but to be regarded as having been filed together with therewith. And then he confirms the facts insofar as they relate to him. So it was part, in effect, of the answering affidavit. At paragraphs 6 and 7, Dana says, I confirm that on Friday, 21 December, McCarthy instructed me to round up the prosecution team. This is immediately after Polokwane. I confirm further McCarthy told me that Mshila had instructed him to institute the prosecution. Now, I don't... is to do so immediately. I needn't go there. We went there yesterday, and Mshila says that's not true. He was away. He was on leave, and he gave an interview to Radio 702 to say it's going to happen the following year. So that was what McCarthy was telling Dana was certainly not true. Then we know that on the 6th of December there was the memorandum which we went through yesterday from Dana, which I needn't go through again, which he expressed his disquiet and said effectively that this is going to come back to bite us. Again, in December 2007, when Hofmeyr asked Mshila how the decision to postpone the prosecution had come about, he confirmed it was McCarthy who persuaded him that it was necessary to postpone the prosecution. He was prepared to support whatever decision McCarthy made. 20 December, that's the Radio 702 interview I've referred to, and 21, I've already referred to that McCarthy gave the go-ahead for the prosecution. Can I come back to the question which was put to me earlier by Justice Ledwaba? Where's this one? Perhaps you care to make a note, page 264 of Hofmeyr's affidavit. At page 339, Hofmeyr says, in June 2008, Mshila wrote to the minister imploring her to take action against McCarthy. To my knowledge, the minister did not respond, despite the findings of the JC.
Which page are you referring us to?
Page 264, volume 4, at paragraph 339. I hope can I just check that if I may? Our pages now, I think maybe 1 or 2 pages now.
Volume 4 page.
I've got 264, it's paragraph 339.
Page 266.
I've got it, 266. It may be 266, paragraph.
Yeah, mine is 266.
266.
339.
Perhaps I should take it from 337. Their report released publicly in November 2007 criticized McCarthy for failing to cooperate fully with the JSCI. 338, on receipt of the JSCI report, the minister wrote to the NPA instructing them to take action against McCarthy and Powell. Mshila had no authority to act against McCarthy, only President Mbeki had the power to act against him. 339, in June 2008, Mshila wrote to the minister imploring her to take action against McCarthy. To my knowledge, the minister did not respond, despite the findings of the JCI. President Mbeki failed to take action against McCarthy. And we know that McCarthy resigned shortly after that and went to take up his position as head of integrity at the World Bank.
So in terms of what is stated here, you are saying the head of the NPA could not take steps against Mshila. It was only the president and the minister
Against
against McCarthy, right?
Yes. That's the view that Mshila had, that he could not take those steps, that it had to be taken by the president. I would imagine on the basis that he's a presidential appointee. Whether he could internally discipline him, I haven't considered.
Yes.
But the policy and the act of the NPA, what does it say? Does it not give him the powers to institute action against personnel who are within his establishment?
Can I look at that and get back to you?
Yeah, you
Lord,
can get back to us
I don't know
later,
the
yes.
answer.
Yes.
Okay.
I know that there have been issues within the NPA as to what steps can be taken in terms of the hierarchy, and certainly in terms of Section 12(6) of the NPA Act, when the President can convene an inquiry into the conduct and suspend pending an inquiry.
Okay, you can come back to us later after you have looked into the point.
I want to then go to the recordings, which are set out in the statement of Mshila at JS10 in the founding affidavit at page 125. On the 7th of November, there's a recording between McCarthy and Ngcuka. McCarthy says to him, "I read yesterday's Business Day editorial. You must just read it." And he said,
JS.
Which volume is it in, Mr.
JS10,
It's 125. So page 125.
120. It starts at 120. It's the founding affidavit,
Which volume?
B1, 1B. The Lordship will recall that they paginated from number 1, starting with the supplementary affidavit, and then the founding affidavit came as a later bundle. These recordings appear in the context of Mshila saying in his media statement, "I will now deal with the contents of some of the recordings set out below. I believe that it is in the public interest to make this available, as this is a matter of huge public interest, and I believe that it is important for members of the public to be able to draw their own conclusions about the nature, I imagine, of conduct." Now, I'm not going to go through every recording. I just want to highlight the following. On the 7th of November, McCarthy says to Ngcuka, "I read yesterday's Business Day editorial. You must just read it." He says, "Just remind me," and McCarthy says, "Yes, it's in line with your thinking." And the comment on the side is that Business Day editorial expressed the view that it appears to be to the benefit of President Mbeki when Mr. Zuma is not facing charges. Then over the page, on the 26th of November, and Ngcuka says to McCarthy, "So you, the only one who can just save this country from its madness." And about halfway down the page, McCarthy says, "Up until Friday, I received a strong memorandum to say, charge and charge now." Ngcuka, "Friday?" McCarthy, "No, this Friday. The team says we have been messing around with this thing. We're allowing ulterior considerations to come in. It will become an impossibility later. We now must take action and deal with finish and claw, as Jackie Salibi says, but we will talk when I see you." And then at the bottom of the page, on the 12th of December, Ngcuka says, "As long as you don't do it this weekend." McCarthy, "If we hold it back, it will be because the clever people like you and others are saying to us that the country needs cool heads, but I would hate to have to be seen to be wrong later." And Ngcuka says, "Just don't do it this weekend." And it continues, "It might change, Ngcuka. I can't keep an open mind. You can't do it this weekend. Our minds won't change." And then he reiterates, Ngcuka says, "Just don't do it this weekend." And McCarthy says, "I won't move this weekend. If this changes, just let us know." And Ngcuka says it won't change. And then at the bottom of that page, 127, 13 December, McCarthy, what is the mood like? Nuka, is it out? McCarthy, no, I'm just checking the pulse of securities. McCarthy, I thought I will give you a call once a day, twice a day, to hear whether the position has not changed. And he said that thing will only be filed tomorrow. They were talking about the Constitutional Court. But what he talks about whether the position has changed, and over the page, you'll see in the next block, McCarthy says, President Zuma will say we are conspiring against him. And McCarthy says, can I ask, the script has not yet changed. And Nuka says, yeah, no. Now I want to then turn to the reasons given by Mshila in this document, and to start off with we know that representations were made. There were written representations followed by oral representations. There were two parts. A briefing was given on the written representations, and the second part was a briefing on the allegations of a political conspiracy. And Hully then disclosed that he was in possession of recordings of conversations, and they also related further examples, they said, linked individuals to a conspiracy to discredit President Zuma. And then we know that on the 9th of March, it was Hofmeyr and Mzinyati who listened to the recordings. And they then reported on those contents. And they said, he says in his affidavit that Hofmeyr says that they were shocked, he and Mzinyati were shocked by what they had heard. But it wasn't only they who were shocked. And it wasn't only Mshila who was shocked when he listened on the 31st. It was also Downer.
Did Downer listen to the tape?
I'm told that he did.
When?
Can I just see if it appears in his affidavit? He says that 3181, it's in volume 33. This is Dana's affidavit. What does he say? Listen to it.
Is that page?
3181.
3181. Paragraph?
Paragraph 83. I can't recall, my lord, whether it says that he listened to the tapes. But he says at 83, I confirm that we were all shocked about the contents of the recordings as they cast serious doubt on McCarthy's integrity. I was reduced to tears, he says. Notwithstanding the content of the recordings, the prosecution team remained convinced that President Zuma's representations for the prosecution to be discontinued should have been declined. But it's quite a statement to make when you're implying shock that a person in the position of Dana says that this, when he found out about this, whether he heard it, I can't say, when he found out about it, that it reduced him to tears.
And this was the information from Hofmeyr and Mzinyati, telling them about the contents of the tape. They were all shocked.
Yes, unless he listened to it himself. And I'll look to see whether, I don't recall seeing that he said he listened to it. So I don't know whether he did or not.
I couldn't pick it up either. That's why I'm asking you this question.
But we will look, and if we find anything about that, we will tell you. But I don't recall seeing it.
You say that Hofmeyr and Mzinyati listened to the tapes on the 9th of March.
Yeah.
And when did they brief the entire team?
Can I? Where's the affidavit of testimony? It starts, I think it would be page.
Just a minute.
Proceed.
In volume 3, from paragraph 249, so I think it may be 243 in your bundle.
Volume 3.
Paragraph 249, page 243.
Page.
243. Volume. This is where he deals with the recordings from paragraph 249. It says the first meeting took place 18 March.
Just a minute, please. 243, paragraph 249. Yes.
Sorry, it starts actually paragraph 247, just before that. And Hoffman says, at paragraph 247.2, we met with Huddy for a second time on 9 March in my office at the NPA. On this occasion, we were able to listen to the recordings. We made notes of what we heard. Between 18 March, at paragraph 248, between 18 March and 1 April, Mshila consulted extensively with the senior management team and with members of the prosecution team about how to respond to Zuma's representations. Then there's the first meeting on 18 of March. The meeting considered 2 representations. At 252, Mzinyati, paragraph 252, Mzinyati and I reported on the contents of the recordings. There was general agreement that the contents were shocking. If authentic, they cast serious doubt on the integrity of McCarthy.
He does not mention when was this.
No. But it seems that is the meeting on the 18th of March. When
18th of March.
It starts at paragraph 249. There's a heading, 18 March. And
would I be right in when you look at the contents of 248, which says that they consulted extensively with senior management and the team about how to respond to Zuma's representation, that D7 finds relevance in this paragraph. That is how it came about that D7 should be drafted.
Well, D7 just says March, but it could be that it came from that paragraph, from those discussions. But at that stage, Mshila had not listened to the recordings.
Yes.
He only listened to recordings on the 31st of March.
But they had briefed him about the contents of the recordings.
It seems so. They say so. The 18th of March. I don't know whether the letter
wants to consult with you.
But he says that he consulted extensively with the senior management team and with members of the prosecution team about how to respond. Yes. And then Dana drafted that D7.
Yes.
But that must have been after the 18th of March then.
Yes.
Before the 18th of March.
No. It can't be before the 18th because in D7 they also refer to the contents of the recordings.
So
you have a
certainly
look
it looks like it could have happened after 18 months.
Yes, well, if you have a look at the concerns that Downer raised there, I think that must have been then.
That comes out of the meeting of the 18 March. Huh? Well, it may not. It may not be as straightforward as that, because if you look at 26253, after Mzinyati and Hofmeyer reported on the contents of the recordings, he says at 253, we were all concerned about the source of the recordings. Halley had refused to disclose where he got them. And 254, it was decided we should ask those bodies with the legal mandate to intercept communications for assistance, namely SAPS and the National Intelligence Agency. Letters were written to both to request whether they were able to shed light on the source of the recordings and whether they would be prepared to allow the NPA access to such recordings to verify the contents. The SAPS did not respond to our request, even though we knew that they had intercepted McCarthy's mobile number. A further issue that concerned Mshila was the fact that Nuka and McCarthy had not been given an opportunity to comment on the allegations against them. Then is a meeting on the 30th of March, and at 257, the prosecution team consulted with Nuka on 2 occasions, 20 and 24 March, to get his comment. And over the page, at 259, I suggested to Mshila that we should give McCarthy a list of questions, like we did with Nuka. I also suggested that we give McCarthy the option of listening to the recordings.
Isn't it
sorry, my lady, can I just take you through it, because it's apropos what you put to me about the timing. 261, both Mshila and I could not understand why McCarthy was being so evasive. 262, Mzinyati and I reported on our interactions with the NIA. The NIA had informed us they were in the possession of intercept recordings of conversations obtained during the course of an investigation into the leaking of the Browse Mole report. We were shown a copy of a certificate signed by a judge authorizing the interception of the recordings. Mzinyati and I listened to the NIA recordings between 26 and 28 March. The NIA played us recordings of conversations between McCarthy and others. The NIA were in possession of most, if not all, the recordings. And then further down, they say what's in the recordings, but at 264, Mshila was undecided about what to do. He had not listened to the recordings himself. So when one looks at D7 and they're framing a letter about following representation and information given, at this stage, Mshila is undecided what to do. He had not listened to the recordings himself. He was reluctant to do so. Initially, he was concerned about the implications of using NI information to make the decision. Matsuka and Ramaiti shared his concern. We knew that if Mshila relied on the recordings, they would have to be made public. Once the NI confirmed they were willing to allow the NPA to make the transfer of recordings to possession and that they'd allow us to make them public, the obstacle was removed. And then on the evening of 31 March, Mshila listened to the recordings. So it may not be that they're compiling, they've got representations, they're preparing a draft, but clearly, at this late stage, he had not yet decided what to do.
Well, what also bothers me, Mr. Epstein, if you look at paragraph 256, a further issue that concerned Mshila was the fact that Nguka and McCarthy had not been given an opportunity to comment on the allegations against them. Mshila felt that this was important to do before he made a final decision. What I want to put to you, what I find strange, is that the questions were sent to McCarthy on the 2nd of April, after the decision had been taken.
I'll have to check that, because I think that they sent it to McCarthy earlier and he responded saying he wants additional information. I'm not sure if it was only sent on the 1st of April.
But what I'm trying to put to you, that Mshila was concerned about this, but he made the decision nevertheless, because that brings the question, why was the 1st of April such a magic date? Why did he have to take the decision before on the 1st of April?
And unless McCarthy had by that stage indicated that he was not going to cooperate.
McCarthy said he wanted to listen to the tapes.
He wanted to listen to the tapes.
Yes. Also, the other thing that is crucial, as my brother raised it yesterday, is that Mzinyati and the Hofmeyer briefed the team about the contents of the recordings. Now, what is it that Mche heard when he listened to the tape that he was not told by McCarthy and Mzinyati that made him to change his mind?
Well, we'd have to speculate about that. Perhaps seeing is believing and hearing is understanding, more in terms of context.
Okay.
But we agree that there's nowhere in his reasons or in the affidavit where he tells us if there was anything new that he found which was not told to him before. There is nothing like that.
In his statement, I don't think he gives the timeline as to when he found out the role of McCarthy, other than what was told to him. I mean, we have a bland statement by Hofmeyer, is we reported to him. We listened to the tapes and we reported to him, told him what was in it.
But they had this meeting where everybody was present, where Mzinyati, where he says in paragraph 252, Mzinyati and I reported on the contents of the recordings. And there was general agreement that their contents were shocking. If authentic, they cast serious doubt on the integrity of McCarthy.
So he reported on the contents, but we don't know the detail that he gave. Can I have a moment? So we go to paragraph 269, where where Mshila had now listened to the recordings. And perhaps if I could ask you to go to the previous page of 266. Until the evening of 31 March, only Mzinyati and I had listened to the recordings. Mshila decided it's time for him and the deputies to listen to them. On the following day, on 1 April, Mshila met with the deputies and with Ngwengwe. It's evident from the record of that meeting that he was disturbed by what he heard on the tapes. Until the night before, when he listened to the recordings himself, he had relied on reports from Mzinyati and me to tell him what the recordings contained. 268, he told us that listening to the recordings had made him angry. He informed us that he could not go on with the case and that he had decided to drop the charges, in other words, to discontinue the prosecution. Mshila felt betrayed by McCarthy. Once he heard the recordings, he realized the extent to which McCarthy had manipulated him and others in the NPA. He understood that McCarthy's insistence that the institution of the prosecution be delayed was not innocent. Rather, it was politically motivated. There's nothing wrong with somebody hearing something and then, or being told something, but then you listen to the recording yourself and it takes on a different complexion. It creates a different meaning, or you realize the extent, as he says, of what was going on behind the scenes. So can I turn to the reasons then? Mshila's reasons in the media statement, and just look at what it is that he said. And I want to, if I may, just highlight certain paragraphs. It's at JS 10, the founding affidavit, page 120. In the middle of the page, he starts off, of course, by saying at the very top, I stand before you today to announce the most difficult decision I've ever made in my life. That was the same ugly decision that the director had to make in the House of Lords decision I referred to. He says, in the fourth paragraph, over the last 3 weeks, the NPA has been engaged in a difficult and painful process of dealing with allegations that the case of Mr. Zuma has been affected by manipulation and abuse of process. We have come across information about collusion between the former heads of the Directorate of Special Operations and NPA to manipulate the prosecutorial process before and after Polokwane elections. We regarded these allegations as extremely serious and set out to investigate them as fully as possible within the limited time at our disposal. I started off yesterday by quoting the DA's own affidavit, criticizing the conduct, stating that it was plainly most irregular and worthy of strong criticism. And they also say in their affidavit, the irregularity of McCarthy's conduct is not to be minimized. McCarthy was not some maverick on the outside of the NPA. For all intents and purposes, he was the NPA at the time. And when the public look at the integrity of the NPA and the independence of the NPA, it's McCarthy they look at. That is why he is the central focus of the entire process that was unfolding. And where Mshila says in the fifth paragraph that they regarded the allegations as serious, we know not only did he regard them as serious, but so did Mr. Self of the ideas I've referred to, Hofma, Mziniati, and it reduced down to tears. Then, if we can go over the page, he deals with, in the middle of the page, under possible abuse of process. In the course of the representations, the defense made certain very serious allegations about alleged manipulation of the NPA and indicated that these were substantiated by recordings of certain telephone conversations which it intended handing into court during the intended application for a permanent stay. And at page 130, he deals with the conclusion, the second paragraph. He says, using one's sense of justice. So it's using his sense of justice. Using one's sense of justice and propriety as a yardstick by which McCarthy's abuse of the process is measured, an intolerable abuse has occurred which compels a discontinuation of the prosecution. And in the middle of the page, it follows, therefore, that any timing of the charging of an accused person which is not aimed at serving a legitimate purpose is improper, irregular, and an abuse of process. A prosecutor who uses a legal process against an accused person to accomplish a purpose for which it is not designed abuses the criminal justice system and subjects the accused person to that abuse of process. Can I take you, Lords and Lady, to Downer's affidavit, volume 33, at page 3177. At paragraph 60, the bottom of page 3177, Downer says, we can start at 59. I confirm, he says, that the prosecution team believed that the timing of the announcement was very significant and may have far-reaching consequences. Now, this is the very person who is insistent on proceeding with the prosecution, but this is his view. 60. I confirm that our disquiet was premised on the delay being seen to be protecting President Zuma for no good prosecutorial reasons. 61. I confirm that the prosecution team did not regard the timing as something incidental to the prosecution. I confirm that the prosecution team recognized that any decision to delay the prosecution for reasons unconnected to the prosecution was improper. I confirm that the prosecution team felt so strongly about this that we had initially decided to resign from the prosecution in protest, but had reconsidered this in the interest of the NPA. I can't put it any more strongly than that of Downer himself realizing the impropriety of what had been going on in delaying the prosecution. And so Mshila continues at page 130 of his statement. In the middle of the page where the paragraph starts, abuse of process through conduct which perverts the judicial or legal process in order to accomplish an improper purpose offends against one's sense of justice. McCarthy used the legal process, he says, for a purpose outside and extraneous to the prosecution itself. Even if the prosecution itself as conducted by the prosecution team is not tainted, the fact that McCarthy, who was head of the DSO and was in charge of the matter at all times and managed it almost on a daily basis, manipulated the legal process for purposes outside and extraneous to the prosecution itself. It is not so much the prosecution itself that is tainted, but the legal process itself. And then finally in the last page, he says in the second paragraph, in the light of the above, I've come to the difficult conclusion that it is neither possible nor desirable for the NPA to continue with the prosecution of Mr. Zuma. And importantly is the following. He says in the fourth paragraph, let me also state for the record that the prosecution team itself had recommended that the prosecution should continue even if the allegations are true and that it should be left to a court of law to decide whether to stop the prosecution. However, I believe that the NPA has a special duty as one of the guardians of the Constitution and the Bill of Rights to ensure that its conduct is at all times beyond reproach. And then he says, as an officer of the court, I feel personally wronged and betrayed, that on a number of occasions I have given evidence under oath that there has not been any meddling or manipulation of the process in this matter. It is with great regret that I have to say today that in relation to this case, I cannot see my way clear to go to court in future and give the nation this assurance. So having been manipulated by McCarthy, he's assuring the entire public in South Africa that this prosecution is untainted. Everything is being done above board. And in truth and in fact, that wasn't what was happening. So, in conclusion, I want to emphasize what I said right at the beginning. At the end of the day, we know that this is the discretion which the Constitution and the legislation reposes in the National Director. It's his discretion. And courts will not interfere unless there are exceptional circumstances within which to do so. And the question to be asked is this. If one sees that the integrity of the National Prosecuting Authority has been impugned, if in the eyes of the public, it can no longer hold up the badge which the Constitution requires that we are independent, we conduct ourselves without fear, favor, or prejudice, without any outside influences, whether economic, whether political. Unless the public repose that trust in the National Prosecuting Institution, then the democracy in our country fails. There is nothing more important. You can't have a constitutional democracy unless you have an independent prosecutorial authority. And one has to ask the question, as he did, as Mshila did, is it more important to pursue the conviction of one person, you must put out of your minds the respect that this was the president. Is it more important to pursue the conviction of one person, even where the merits may appear to be good? Or is it rather more important to assure the public that at any cost, the prosecutorial authority will not be impeded, it will not be affected, it will not be influenced by outsiders, and it will always remain independent? It's like the judiciary. There may be cases where your lordships will have heard and will hear where there is strong evidence against an accused, but it's inadmissible. It's hearsay. And even though you know it's true, you have to disabuse your mind of it, you have to ignore it, and that person has to walk free. Why? Because those are the rules we abide by. Those are the rules, and mostly the rules will provide what we need. It will provide justice in the end. But we cannot allow the pursuit of one individual to trump the independence that we require of the NPA. And I want to end off by referring to the case of State versus Mohammed. We've only photocopied the head note and the relevant page that I want to refer to. It's a very long decision of the Constitutional Court. And this really makes the point that the pursuit of the prosecution of one individual must yield to the greater public interest in assuring South Africa that its NPA is independent. We know that there's a lot of public sentiment about this case. It's been going on for years. Everybody knows about it. And one, with respect, and I don't want to give the bench with respect to jury speech, but one can't allow that kind of sentiment to trump what is most important, and that is to ensure the integrity of the National Prosecuting Authority. And in the matter of State versus Mohammed, the court said, and if I can refer you to the last page which we have attached, at paragraph 68, South Africa is a young democracy, still finding its way to full compliance with the values and ideals enshrined in the Constitution. It is therefore important that the state lead by example. This principle cannot be put better than in the celebrated words of Justice Brandeis in Olmsted et al. Versus United States. And then he quotes, "In a government of laws, the existence of the government will be imperiled if it fails to observe the law scrupulously. Government is the potent and omnipresent teacher. For good or for ill, it teaches the whole people by its example. If the government becomes a lawbreaker, it breeds contempt for the law. It invites every man to become a law unto himself. It invites anarchy." And I emphasize that the NPA at that time was McCarthy. I just want to deal with one final point, and that is the question of relief in this case. If I can ask the court to refer to the founding affidavit and the notice of motion.
Will you be done with your point in about 3 minutes, or maybe we can give you an opportunity to deal with it after tea?
It won't be long, but I may take more than 3 minutes. So can I just deal with it after tea? Otherwise I'm finished. Thank you.
We'll resume at 11:30. Court adjourned.
All right.
Can you call the report when you get the same number? Katakan testa 1 2 1 2 1 2 1 2 1 2 1 2. Bishop. So 1 6. So 1 6 1 2 1 2 1 2 1 1 1 1 1.
Is at the discretion of the NPA head Mshila at the time, and that decision was not to prosecute. McCarthy had manipulated the process.
Quickly before they come back from tea.
Yes. We're still waiting for as soon as they call us. Okay, so McCarthy had manipulated the process and he did lobbied for people. We also had a conversation with Willie Hofmeyer on why the decision to prosecute President Jacob Zuma should be delayed back in 2007 and why it was not prudent to prosecute Jackie Silibi, the former police commissioner. Jackie Silibi, the former police commissioner at the time. To prosecute the former police commissioner at the time. So basically what Epstein was trying to prove there is how the processes, the prosecutorial process or systems were being manipulated by Leonard McCarthy at the time.
Okay, I'll please stand by.
But they haven't called us yet. They haven't called us.
That's fine. We'll just want to talk to them. They're not answering, you know. And this thing is going to start now.
But they haven't called, eh? Abaga phone ilabantu laba.
Just but let us be ready, guys. Let us just be ready. Don't worry, let us be ready. Give them the number.
You gave them?
Somebody
gave them.
They've been called through MCR.
Yeah.
Yeah, but we're going to speak now. Within 5 minutes. No. I know that. But the first things first. Please, there's nothing wrong in saying, please, quickly. There's nothing wrong with that. Because when I started this thing, we don't get it. So money
Let's go back inside where Advocate Epstein is concluding his arguments. After that, we'll have J. Kemp, who is President Jacob Zuma's legal counsel. He'll be then leading evidence. Okay, the major thing coming out of this arguments led here by the NPA that it's not within the interest of the public to prosecute President Jacob Zuma, and it's not within the interest of the integrity of the NPA. The NPA should be seen to be beyond reproach. It must be seen to be independent. And if you take into consideration, as he puts it, the manipulation of the judicial system, the manipulation of the prosecutorial system by Leonard McCarthy, it would be seen as if the NPA is not independent. And that conversation that NPA had at the time, Leonard McCarthy had with the former boss of the NPA, former boss of how far he would go to manipulate the system. Says that President Thabo Mbeki emerges victorious. That's a big question here. Okay, we have a call here. Hello. Shomareka. Okay.
Tell them to come to you quickly because
they're with me now, yeah? Sure. Yeah. Yes, I'm listening. No, we're going inside now. This thing is starting now. Yeah, this thing is starting now, my guy.
It's starting now. No.
Send me a proceed.
Before I turn to relief, I was asked earlier about the powers to deal with a Deputy National Director, which Mr. McCarthy was. He was a Deputy National Director, and he's appointed by the President, and Section 12(5) says, there's the MPA Act, the National Director or a Deputy National Director shall not be suspended or removed from office except in accordance with the provisions of subsection 6, 7, and 8. And 6, 7, and 8 are where the President may provisionally suspend the National Director or a Deputy National Director from his or her office pending such inquiry into his or her fitness to hold such office as the President deems fit, and subject to the provisions of this subsection, may thereupon remove him from or her from office for misconduct, ill health, incapacity to carry on an account that he or she is no longer fit and proper to hold the office. On the question of relief, in the founding affidavit, the relief sought is in paragraph 2, page 1 of B1, reviewing, correcting, and setting aside the decision. It says of the first applicant, that's obviously a mistake, means of the first respondent, taken on or about 6 April to discontinue the criminal prosecution of the third respondent in accordance with charges contained in an indictment of 27 December 07. And 3, declaring that the decision of the first respondent referred to above to be inconsistent with the Constitution. On the 6th, we know that the announcement was made about the withdrawal of the that the prosecution is going to be discontinued. On the 8th, 2 days later, President Zuma appeared in the Durban High Court where the charges were withdrawn. So all they're asking you to do is to declare the announcement unconstitutional because the charges have been withdrawn. They're not asking for the charges to be reinstated. And in the case of freedom under law, if I can give you the references, 2014, volume 1, page 254, in the North Gauteng High Court. This was the judgment of Murphy J. And in that case, the relief they applied for in a review was setting aside of the decision of the first 3 respondents relating to the withdrawal of criminal and disciplinary charges against the 5th respondent, that was Mhluli. Full also sought an order directing that the charges be immediately reinstated and prosecuted to finalization. And Judge Murphy gave them that relief and directed that those charges be prosecuted to finalization. But on appeal of the Supreme Court, that reference is 2014, volume 4, 298 SCA. And at paragraph 51, Brunt J.A. said this: what remains are issues concerning the appropriate remedy. As we know, the court, I quote, did not limit itself to the setting aside of the impugned decisions. In addition, it ordered the NDPP to reinstate all the charges against Mhluli and to ensure that the prosecution of these charges is enrolled and pursued without delay. And B, directed the Commissioner of Police to reinstate the disciplinary proceedings and to take all steps necessary for the prosecution and finalization of these proceedings. Then Branche continues, both the NDPP and the Commissioner contended that these mandatory interdicts were inappropriate transgressions of the separation of powers doctrine. I agree with these contentions. That doctrine precludes the courts from impermissibly assuming the functions that fall within the domain of the executive. In terms of the Constitution, the NDPP is the authority mandated to prosecute crime, while the Commissioner is the authority mandated to manage and control the SAPS. As I see it, the court will only be allowed to interfere with this constitutional scheme on rare occasions and for compelling reasons. Suffice it to say that in my view this is not one of those rare occasions, and I can find no compelling reasons why the executive authority should not be given the opportunity to perform their constitutional mandates in a proper way. The setting aside of the withdrawal of the criminal charges and the disciplinary proceedings has the effect that the charges and the proceedings are automatically reinstated, and it is for the executive authorities to deal with them. The court below went too far. So in that case, they asked for the withdrawal to be set aside. In this case, they're not asking for that. They're asking for the decision to be set aside.
Well, then we needn't deal with the withdrawal and the reinstatement.
So if you give them the relief, my lady, then all that happens is it will have to go back to the NPA to reconsider. The charges won't automatically be reinstated. That's the only point I'm making.
To reconsider what?
To reconsider whether to proceed or not proceed.
Has that decision not been
In other words, you will have found, my Lord, I'm sorry to interrupt, you will have found, if I'm unsuccessful, that the decision was irrational, and then that decision will be set aside, and then the decision have to be reconsidered by the present NDPP. But the charges won't automatically be reinstated.
No, that's right.
It's not what they've asked for.
The prayer in the notice of motion says review, correct. And this court will decide as to how is it going to correct this whole issue if it grants an order in favor of the applicant. But now you submit that there's no prayer that the withdrawal should be set aside.
Yeah.
Am I with you?
That is so.
But the withdrawal of the charges was as a result of the decision of Mr. Mshila.
Yes.
Now, if that decision is set aside, would the withdrawal still be valid?
Yes, it will be. The withdrawal is still valid. It's only the decision that's set aside. They haven't asked you to set aside the withdrawal. It must go back for reconsideration by the new NDPP. And I would, with respect, alert the court to what
I
this...
think maybe it will be the decision of the NDPP to make, because if the decision is set aside, the NDPP would decide whether the withdrawal is not an acquittal. We all know that.
Yeah.
Yeah, but if we set aside the decision, then
It have to be
the
retaken.
NDPP will decide what we will do.
With respect, that is so, Lord. Thank you.
Thank you. Mr. Kemp, are you ready?
Thank you. My Lord and Lady, may I commence to refer you and to quote you just parts of 2 paragraphs of a case of State versus Lamini. It's a 1999 Ford SA 623 Constitutional Court judgment. In the judgment at page 93, Justice Kriegler says, choices often have to be faced by people living in open and democratic societies. Indeed, the right to make one's own choice is an indispensable quality of freedom, and often such choices are hard. Litigation in general, and defending a criminal charge in particular, can present a minefield of hard choices. Then he explains this by way of example. I would want you to consider that Mr. Mshila in this matter had a hard decision to make, and I also wish, because it seems to me that there has been some tendency on the part of the applicant to label the timing of charges as essentially an irrelevancy. I would wish to draw your attention to the decision, and we've referred to it in our heads as well, to the decision of Sanderson versus Attorney General, Eastern Cape. It's a 1998 2 SA 38 Constitutional Court decision. And in that decision, the Constitutional Court deals with the fact that since the Constitution, there has been a significant break from the common law past. Kentridge AJ suggests that criminal trials should be conducted in accordance with open-ended notions of basic fairness and justice. I will suggest in a moment why the fair trial protection of the accused extends to known trial-related prejudice. But my point here is simply that a narrow textual approach to Section 25(3) is likely to miss important features of the provision. The point that we would like, and we would make it in more particularity with the case law on the point, is there has been a tendency to equate the decision in this case to a permanent stay. I am well aware that the third respondent has been accused of that by the applicant. For reasons that will become apparent later, that is not what we have done, and that is not what we're asking you to do. But we do want to make the point right at the outset that a stay of prosecution or a decision not to continue prosecution does not necessarily have to have anything to do with the so-called merits in the sense of substantive facts making up the offence of the case. That is what the Constitutional Court says here. They say it extends to known trial-related prejudice for rights to a fair trial. And that must be so for a variety of reasons. But we say, if you are looking for basic authority with the contention that a permanent stay or the exercise of a discretion can only be where there is an impacting on trial-related rights of the accused, that is simply wrong as a starting point in our jurisprudence. In this case as well, the court refers to inter alia the effect of charging a person and him becoming the accused and the negative effects and penalties and prejudice that results simply by virtue of being an accused. These forms of prejudice are unavoidable and unintended byproducts of a system, the court says. It should really only be visited on the convicted. And the court reminds us of the past, and it talks about vague statutory crimes which gave the state sweeping scope to investigate, charge, and prosecute opponents of a governing party. And one may well add in this instance, opponents of certain factions in the government and governing party. We say, my lords and lady, that it is simply even wrong to suggest that any timing of the bringing of charges is a trifling matter. It is not. It is in itself not. But in this case, we will deal with why it is in particular not a trifling matter in this case. If I may then start off by putting a certain proposition about applications, which I am certain you are well aware of, and what I wish to draw to your attention really is what has come up in argument. The DA, the applicant, contends that, no, they have a different interpretation of what the recordings may mean or do not mean. It is not an exercise of interpretation. My learned friend, Mr. Epstein, has referred to it, but it's not a matter of assumption either. It's a matter of inference. And it's only if the national director had drawn irrational and unreasonable inferences that you can say that the factual matrix in which he made the decision flaws his decision. It is not with respect for the court in a situation like this to say, but we think the tapes mean that, unless you find that what the national director understood them to mean is wholly irrational and cannot be a reasonable interpretation thereof. And in that regard, if I can just make the submission to you, the fact that the persons in the National Prosecution Authority were better equipped than the court to draw the inferences from the recordings is also a factor that I respectfully ask you to consider. That knowledge that they had of the persons involved, how they speak, etc., is part of the inferential material that was available to them. Now, in these papers, the National Prosecution Authority has spelled out its version. That version accords with the record. The third respondent confirms it in several respects, and the documents bear it out. This application must be determined on the respondent's version. If the applicant did not want that, it had to ask for oral evidence or to cross-examine somebody, etc. But apart from that, and my lords and ladies, I know the hard way because I learned it in NDPP versus Zuma that is exactly how an application is approached, and we were on the receiving end of that. And in this case, you have a respondent's version. That is the version on which I am going to address you, and I make the submission to you that you're not free to choose the DA's version, even if you think it's more probable. That is not how disputes, insofar as there are disputes, are resolved in application proceedings. The NPA's version is not incredible, it's not irrational, and the NPA did not have to disprove the account of the applicant. The applicant had to disprove on paper the NPA's version. So as far as that is concerned, I am going to address you on the version put forward by the NPA. May I then make the first point of significance about this application and what it seeks. This application was misconceived. It started out as a Paja review. Hence, you will see paragraph 2 of the order declaring the decision unconstitutional was premised on section 33 of the Constitution and sections 8 and 9 of Paja. That challenge is clearly wrong. The DA subsequently realized that their administrative law challenge was flawed. It was fundamentally flawed. And May I, my learned friend has drawn your attention to the decision, and we've also referred to it. In the case my learned friend referred to, freedom under law, if you, he's given you the citation, it is 2014-1. I'm sorry, I'm looking at the SCA. Sorry, it is 2014 for SA 298 SCA. If the court looks, when you look at have a look at the decision at paragraph 19, you will see that the SCA says, with reference to this very application, which was before it in the matter between the DA and the NDPP, the 2012 free decision of the SCA. And in that decision, Judge Nafsa said, listen, I don't know why you are trying to distinguish between a decision not to prosecute or a decision not to continue with a prosecution and a decision to prosecute. They're all the same. But he said it's not necessary to decide that because everybody agreed that, look, at least for legality review, there was standing. In the freedom under law judgment, the court says the following. Although the answer to that, the allied issues where these decisions are reviewable under the provisions of PAJA, although the answer to that question is by no means decisive of the matter, I nonetheless believe the time has come for this court to put the issue at rest. And the court then deals with the issue and it decides it that there is no PAJA review against the decision of the NDPP, whether it's a decision to discontinue prosecution, whether it's a decision not to start prosecution, whether it's a decision to prosecute, it does not matter. None of them fall under PAJA. They do not fall under PAJA. There is a limited review parameter, and that is legality, and in a case like the present, it can eventually only be irrationality. It can't be anything else. You will see that he refers, in discussing the matter, he refers to the judgment of Mr. Justice Nafsa, etc., and then he says, as I see it, that's in paragraph 26, the underlying considerations of policy can be no different with regard to decisions not to prosecute or to discontinue a prosecution. The view is supported by English authorities dealing with non-prosecution, and the court cites them. And he then says, my conclusion is that policy considerations are underlying our exclusion of a decision to prosecute from a PAJA review are substantially the same as those that influenced the English courts, to limit the grounds on which they would review decisions of this kind. And he says the English courts were persuaded by the very same policy considerations to impose identical limitations on the review of decisions not to prosecute or not to proceed with a prosecution. In the present context, I can find no reason of policy, principle, or logic to distinguish between decisions of these two kinds. Against this background, I agree with the arbiter dictum by NAFSA in DA versus acting in PP, that decisions to prosecute and not to prosecute are of the same genus. And although on a pure textual interpretation, the exclusion in section 1FF of PAJA is limited to the former, it must be understood to incorporate the latter as well. So that makes an end to the PAJA review. And in support of that review, the DA had suggested very clearly that Mshila was either motivated by personal ambition and the prospect of a permanent appointment as NDPP by Zuma as no reward for the 2009 decision, or he buckled under political pressure. And it is quite interesting, my lords and ladies, to have a look at what the Supreme Court of Appeal, indeed in the 2012 Free matter, had considered the issue to be. The court in that matter had considered the issue to be precisely what I've just read to you. Well, did he buckle to political pressure and therefore his decision was unlawful? Or was it otherwise a dishonest decision? And that was what this review was about. Now you know that that is no longer what this review is about. You know that the DA has accepted the bona fides and the honesty of Mr. Mshila in deciding on the issues before you. It follows, my lady and lords, that there is nothing left of that review. What you have before you is now a resort that, look, as a last desperate position, we say that this is irrational because. Why? What did the applicant pitch its case at? It says the NDPP did not sufficiently, or as I put it, not at all consider the strength of the case against the NDPP. That is the case that it now makes out. My lords and ladies, I do not need to dwell on that. That is simply not correct on the papers. You see Mr. Mshila in his public announcement. Mr. Mshila says, I was unpersuaded not to proceed with this prosecution by anything on the merits that the accused made to me. I considered the merits were good on the substantive side of proving facts, at least on some of the charges, one would assume. So, how can anyone say that he did not have that aspect of the case in mind? May I then draw, and if I may just perhaps whilst I'm dealing with that, in the case that I have referred you to, the 2012 3 SA 486 SCA DA matter, in paragraph 45, the SCA said, the question whether in making the decision to discontinue the prosecution of Mr. Zuma, the NPA had acted in accordance with the law or had wrongfully and unlawfully succumbed to political power and influence as alleged by the DA is a matter for decision in the review application. After all, the papers have been filed. The fact of the matter is that that is no longer the issue before you. The only issue before you is what I have just now put to you. And, my lords and lady, I wish to refer you to some of the documents that have evoked considerable interest of the court. If I can say to you, it seems from the record that the first response of the prosecution team, detailed one, was made on the 18th of March. There were previous responses, and then my lords and ladies will also see that there was a detailed proposal by the team as to how to react. My lord and lady will find that at C28 and also at D7 of the record. And may I say, and I'll see whether I can find it for the court, it seems to me that the contents of the representations were conveyed to the team approximately the beginning of March. But the contents of the tapes, as established by Mr. Hofmeyer and his colleague, was given to them on the 18th of March. And they referred to being advised of that, and they then provide a memorandum, and they provide a letter, and you will see the letter at D7, and it seems that that letter was received on the 30th of March by the NDPP, and if one looks at the records and the chronology put up by the applicant and by the first and second respondent, we know that there was a meeting on the 30th of March between the team and the NDPP and the top management as well. So, my lords and ladies, this letter says very clearly, and it's a draft that they put up and they want Mr. Mshila to send. They say, well, you know, we think that you should do this. And in that, they do say that the merits are strong. They deal with that, and they want the NDPP to tell the third respondent's attorney that. They deal with the fair trial issues. They say, well, that this section of our response is just limited to trial delay and adverse publicity. And then you will see at D14, they go on to deal with the oral representations, etc. And they say, from the oral representations which you have made, and the reports by Mr. Hofmeyer and Advocate Mshila on the material to which you granted them access, I understand your client's main allegations to be the following. And then you will see it says that conspired to support the former president, McCarthy manipulated the timing, and then Mr. McCarthy abused his position by instructing or allowing certain erstwhile employees of the DSO to gather intelligence regarding your client, which culminated in the production of a so-called Browse Mole report. Mr. McCarthy had improper communications with a member of the media and someone believed to be a foreign intelligence operative regarding the prosecution of your client. That probably refers to the leaking of a 8-page memorandum, etc., etc. But be that as it may, the prosecution team, and I do not really want to call them that because there's a sort of automatic assumption that the prosecution team excluded people like Mr. McCarthy. That was not what is reflected in the various litigations, nor were Mr. Downer and Mr. Steinberg and Mr. Baloy carrying the can on their own. You can look at the reported cases, you can see I had counsel, other members of a team in what were criminal cases. So those people were part of a prosecution team for those purposes. The proceedings before Judge Msimang was part of a criminal proceedings. It wasn't some other application. The Section 179(5) application was a separate civil application, but not that. So what I am submitting to you is that the members of the team feel confident enough about what they know and what Mr. Mshila know and what the oral representations were, and they've seen the written ones. One can see it because Mr. Downer refers to excursus B, and as we've drawn attention to, he could only have known that there was an excursus B if he had read the written submissions. You will see that he says these allegations have come as a complete shock to me. That would now be Mr. Mshila and the other members of the top management of the NPA. Without the material to which I would hardly have been able to give any credence to these claims. You will see that what he is saying is, I'm beginning to understand now what you're saying about the Brass Mole report. If it weren't for this, I would never have believed what you were saying to me about it. I must say, I would certainly think that Mr. Mshila had before February 2009, he knew about the Brass Mole report. How much he knew about it, one does not know. I can also say to you that it is pretty clear from the affidavit filed by the third respondent, is that the whole Browse Mole thing became really a public knowledge item as to more or less what happened there. When Mr. Bakoli was engaged in his battle before the Gingwala Commission and in the subsequent civil litigation, it is in there that this became more or less public knowledge and detailed knowledge about that emerged, because Mr. Bakoli was being blamed for the Browse Mole debacle. And he was, of course, defending himself and saying what actually happened. But what I'm drawing your attention to is there is no doubt that Mr. Mshila has before him, and he says, I read and I considered and I valued the input from various members of the NPA, including the team. They tell him that the merits are strong. How can anyone suggest that he did not have that in mind? You will see in the chronology of the meetings on the 18th of March and the 30th of March, Mr. Mshila says, well, we don't have to discuss the merits further. We all know that they are good. We all agree on that. So how can anybody make the submission with success that Mr. Mshila did not know about that, and he did not have that in mind when he made the decision? And if that is so, where does this review go? It goes exactly nowhere. There is nothing about that that says that now he knows about it, that he, on the 31st of March or the 1st of April, went and drew a line through the merits. On the contrary, on the 6th of April, he still sticks to saying, well, the merits are pretty good. So that line of attack on the decision is, with great respect, still born. It is not even something that you should give any credence to. So, if that is the rationality attack, it has failed. It has failed at the outset. If you decide it has failed, it does not mean that you have said that the allegations made by the third respondent or his representations are true. It simply means that the applicant has not on the papers demonstrated the irrationality. It is not necessary for you to delve into these allegations and to find out whether they are true. Of course, the third respondent contends they are true, but it's not necessary for this decision. And you can deal with a matter very simply by saying, well, this is a rationality complaint. Mr. Mshila had it in mind. He dealt with it. The team who were in the best position to advise him as to the merits did. They agreed on what the merits were. It just seems, with respect, wholly irrational to say that that is the basis of a rationality challenge, that he did not. What the DA says is something else. What the applicant says is, we don't think that he put enough weight on that consideration. But that is a different exercise. That is not a rationality exercise. That is an exercise when you ask whether the decision is reasonable, etc., etc. It is not a rationality exercise. May I then say to you that one must look at the NPA's decision in the context of the answers given by Mr. Hofmeyer and confirmed by Mr. Mshila. You will also see Mr. Downer confirms the essential interference on the part of McCarthy as gathered from the materials, and his view is also that this was a very serious matter. You will see what the team says about these things in the letter. It is clear that they say that this is serious. It is not something that can be wiped under the carpet. And may I put it to the court at this level? It is an enormous affront to the criminal justice system. It is an enormous affront to civil society and the people's structures of governance. The choice of a president is of great importance in how we govern this country. In this case, what you see is the NPA with its enormous powers to indict people and to prosecute them and to use their powers in a criminal justice system as to when they do that. These powers are now blatantly used to try and decisively influence the outcome of the presidential election process. We say to you, that is an enormously serious thing. It is not whether there is a delay of 7 days in the issuing of the charges. That is not what this is about. This is about why were the powers used in that way. And it was used in that way to try and inflict a very significant event upon the people of this country. There is no other way of looking at it. If you just take, for example, if someone who had to decide on when to arrest the president at that stage, and they knew that there were riotous conditions likely in a certain jail, and they arrest him so that it coincides with the information that there's going to be a riot in that prison, and let's put him there and let's hope for the best. If that gets found out, whether he is killed in the riot or not, it will be an enormous misstep. It will be an enormous abuse of the NPA's powers. The fact that it didn't work out in this case, like the persons involved in this planned, matters not. It does not matter. It cannot be that if I stood before you today, and as a result of this strategy, Mr. Zuma, who would then not be the president, lost at Polokwane as a result of this strategy, that you would say to me, but it was insignificant. It was just a matter of timing. And what does it really matter whether he gets the indictment a week early or a week late? That is not what this case is about. It is not what Mr. Mshila's decision is about. His decision is about the enormity of what you were trying to achieve by perhaps a very simple step, and a step that in itself isn't so significant maybe in the grand scheme of things in this prosecution. But it was enormously significant for some other reason. And, my lords and lady, if the DA is right that, because it didn't happen that way, it is nothing, then we deserve to be told that, so that the people will know that nothing really happens if somebody in the NPA does something like this. And may I come to the decision of Mr. Mshila? And yeah.
Before you go to the decision of Mr. Mshila, on the basis of the communication between Mr. McCarthy and Mr. Ngcuka, they are assuming that everything is correct and was obtained legally. Was their aim not to that the service of the charge sheet should have an impact as far as the election is concerned?
Well,
and that had nothing to do with the charges themselves.
Well, may I put it to my lord this way? As I understand it, the whole idea about delaying the service of the charge sheet was this would improve the prospects of Mr. Zuma not being elected at Polokwane. You may say to me it's counterintuitive. You may say a lot of things about it. But if you ask for the reason why it was delayed, that is the reason. And the fact that it didn't work doesn't change that what we have here is an NPA that will allow its powers and will exercise its powers to secure certain political results. That is what this case is about. It is not, my lords and ladies, may I say to you, if the trial goes ahead, forget all the other skirmishes about permanent stays and things like that. The fact that the indictment was served, say, on the 28th of December rather than the 1st of December or the 31st of January matters very little to that trial and its outcome. That is not what this case is about. I accept that. And it has never been suggested otherwise as far as that is concerned.
So I would then say that the position held by Mr. Downer, you'll recall that Mr. Downer and his team have consistently argued that the question of service of the indictment must not take into account extraneous matters.
Yes.
Be they political, whatever. Whether they are serving on the president or whoever on the eve of elections.
Yes.
If they decide to serve, they need to serve.
That was his stance.
Consequences before.
Yeah.
Now, would you characterize that as the correct position?
My lord, yes, in principle that is the correct position. I am not saying that if there are valid reasons, you can't serve it later or earlier, other than simply the merits. But what I am saying to this court and what we are contending for, that in this case, the reason for that was very different. The reason was to have a different individual as president of the ANC. That was what this was all about. And that is an enormous thing. It is like we are arresting somebody that we know is going to be a kidney donor to Mr. Zuma. We know he's critical. If we arrest this person now instead of in a week's time, maybe it will be too late. If it happens that another kidney is found after you've done it, it does not change the enormity of the abuse. The abuse is not, well, you get it a week earlier or you get it a week later. It is, what is the NPA's powers being used for? It's being used to determine who is going to be the president of this country. That is exactly what Mr. Justice Harams had in mind when he says, well, if it's being used for an ulterior purpose, that is quite different. And you will see that is how Mr. Mshila saw it, that's how Mr. Hofmeyer saw it. And other members of the team and of the top management also saw the significance of it. It is not that Mr. Downer and Mr. Steinberg did not realize afterwards what had happened. They were differing about, well, what do we do about it? Do we go to court and say, oh, this is terrible and we're sorry, we have to make all these concessions? Or do we discontinue the prosecution? They were never saying that this was not gravely serious. My lords and ladies, I ask you, Mr. Downer is a trial lawyer, he's a hardened trial lawyer. He didn't cry when Justice Msimang kicked out their case. He didn't cry tears of joy when they won battles against us. What does he say to you? He says, I cried not when I heard Mr. Mshila's decision, when I heard what Mr. McCarthy had done. Mr. Steinberg refers to this as Mr. McCarthy's Machiavellian reasons. Both of them understand what is going on. Mr. Hofmeyer understands, Mr. Mshila understands what is going on and what this is all about. This is about using the NPA's powers to have a certain political structure in this country. How can that ever be lawful? How can that ever not be gross and grave? And if one looks at Mr. Mshila's announcement, he is talking about that. He's not talking about the fact that the indictment was served a week later. He says, I'm standing up before you and I'm telling you about this and I make this decision so that these things never happen again in the NPA. He's not talking about an indictment being served a week early or a week late. If you read that announcement like that, it is because you do not want to read it in a sensible sense and meaning that it actually does convey. What is Mr. Mshila saying? He is saying, well, in this case, there were outside people, and no one has ever tried to explain why Mr. McCarthy was discussing all this with Mr. Nuka, which we know from the context of this litigation is a fairly sworn enemy of the president. Why is he discussing these things with him? Why is he discussing the case with him? Why is he giving him an 8-page summary of all the good points in the Section 1795 litigation that is pending and in the warrants? He gave him the 8-page summary in the connection to the warrants appeal. Why? And if you look at it, what Mr. Mshila is doing and saying is actually something very laudable. And it's a clear message to the government and to the president and to every other president. What Mr. Mshila is saying is, look, if you use, and if officials, the high heads of our National Prosecuting Authority, use their powers to engineer political results, we will tell you what we will do. You want us to prosecute this person on your terms. We will tell you what we will do. We won't prosecute him. Now put that in your pipe and smoke it, and see whether you're going to try that again. If you read what he is saying, that is the sense and sensibility what he is portraying. How is that not something that should not be upheld and not be lauded? And there is no effort to grapple with that aspect. There is no effort on the applicant's part to understand that Mr. Mshila is giving a message in that conference also to the government and to political parties and to members of the NPA. He says, keep away from this. If not, this is what will happen. You may say it's an overreaction. You may say he should have chosen a different case to make that stand. But it happened in this case. And that is why he did it. You may not like it. I may not like it. I may also feel that if somebody has committed a crime, he should normally be prosecuted. But you cannot say that that reaction and the reason for it is irrational. It is indeed, as I have put to you, laudable. And if you look at what he is saying, he is, as my learned friend indicated to you, he is saying that in his statement, as an officer of the court, I feel personally wronged and betrayed that on a number of occasions I have given evidence under oath that there has not been any meddling of or manipulation of a process in this matter. And that is correct. He gave such affidavits also in the proceedings before Judge Msimang. And may I make it very clear to the court what was an issue in that case. There were two things in issue. The prosecution wanted an adjournment. That was resisted. And it was not just idle resistance. There had been 6 months set aside for this trial. And there were a great deal of unhappiness about this. There was also, in response, a permanent stay application brought. It is in that application that the allegations were made that Mr. Nka and Mr. McCarthy in 2003 decided, no, it suits us to push Mr. Zuma to the side and then to prosecute Mr. Sheikh, and the harm to the then Deputy President would be far greater. And if we're successful in the prosecution, great, then we've got a platform to have a go at him if we cannot make him go away otherwise by then. Those allegations were made. There were also a number of other allegations, including that the 2005 decision was a hasty decision. Judge Msimang dealt with the application for the adjournment first. That was refused. The state stood there. They said, we're not withdrawing, we're not going on, we're not doing anything. It was then struck from the roll, and there was nothing to bring a permanent stay against, because as we know, both the SCA and the Constitutional Court thereafter reaffirmed that there was nothing left of those proceedings. So, where the sting lies of a brass mold in the current proceedings, it lies at a level, and you will see that there are allegations made in our papers and in the NDPP's papers in some detail about the brass mold and what happened and what happened. The real sting in the allegations was Mr. McCarthy, in August of 2006, deposed to an affidavit which we have quoted both in our heads and in the papers, in which he said that the NPA had observed the highest standards of ethics, lawfulness, propriety in investigating the matter against Mr. Zuma and in prosecuting him. And may I ask you to note the date? This was August 2006. At that stage, as we later know and as we've set out, at that stage, Mr. McCarthy is still busy with a brass mold investigation. He knows by now, and may I say to my lords and my lady, you will find no mention of it in those papers because nobody knew about the brass mold thing. And I have asked to check. You will even, before Mr. Justice Nicholson, I don't think there was any reference to the brass mold issue. It is something that became acutely known later. What you will find is at that stage when he makes that affidavit, and this is now an affidavit to persuade the court to reject the permanent stay application. So it's an important document. He makes those allegations. He is busy continuing with the brass mold. We learn 2 years, year and a half later, that actually Mr. Pakoli had told him, look, this is illegal, you must stop it. He did not stop it. What we complain about and what our complaint was, how can you, as a national prosecuting authority, say that to a court when you know what you are busy with? And may I make it very clear, I do not blame anybody from the prosecuting representatives who were in that court litigation. They did not know about it. I accept that. But Mr. McCarthy knew about it. He was the one doing it. And he was the one who made that main affidavit. And it was him that Mr. Mshila was supporting. And when he complains and says, I feel wronged and betrayed because I gave evidence on oath that there was nothing wrong with this, I can't ever do that again. And if you look at Mr. Hofmeyer's affidavit, you will see that he says, well, you know, we have always said that the allegations of political meddling, interference, and political manipulation of this prosecution is the biggest load of hogwash that we've ever heard in our lives. And he says, well, when I saw this, and I saw these tapes, and I heard what they're still saying about these things, and I heard what they're saying about the Prousmol, and you will see Mr. Downer and the team saying, well, we sort of now understand where Prousmol fits into the thing after the representations, which seems to me to be quite correct, because Mr. Downer and Mr. Steinberg knew about the Prousmol, I think, from probably the end of 2007. But they didn't know any detail, and as far as we know, they were never involved in any of those things. And my lords and lady, you would also have seen we've never made any allegations against them and been involved in what we're talking about in this matter. So, what you have, and we say, the courts in England, and you would have seen that in the judgment of the appeal court that we have referred to, Freedom Under Law, you will see that the South African Supreme Court of Appeal has regard to the English decisions on this. And whatever may be the position as far as abuse by the executive is concerned, and I'll deal with that, and I will refer you to the latest cases, or the most authoritative latest cases on that issue of permanent stays, etc. But if I may say to you, there is a difference between an abuse of power and an prosecutorial misleading of the court. An abuse of power by the executive is dealt with in a certain way. As far as the prosecution is concerned, I have quoted to you the decision in Early. I will give the court a copy of that decision as well. Early and those lines of cases have never been retracted or detracted from in the jurisprudence. They all proceed on the basis that you tell an untruth to a court about a material issue for the prosecution and see what happens. In Early, the court said, judges can only make decisions and counsel can only act and advise on the basis of information with which they are provided. The integrity of our system of criminal trial depends on judges being able to rely on what they are told by counsel and on counsel being able to rely on what they are told by each other. This is particularly crucial in disclosure and public interest hearings, public immunity hearings. And they say, furthermore, in our judgment, if in the course of a public interest immunity hearing or an abuse argument, and I leave out one or two words which are not important, prosecution witnesses lie in evidence to the judge. It is to be expected that if the judge knows of this, or this court subsequently learns of it, an extremely serious view will be taken. It is likely that the prosecution case will be regarded as tainted beyond redemption, however strong the evidence against the defendant may otherwise be. It is one of the cases why we say to you, it is simply not so that strength of case makes up for everything else. In what we say in this case is, and in Early's case, the same thing happened. In that case, the accused pleaded guilty. They were found guilty, and they were sentenced, and then they found out that the prosecution had actually not told the entire story to the court as to how they were arrested, how they were made to participate in this custom scam by certain entreaties, etc. And they did not know that at the time, and the defense counsel didn't know it, and even the prosecution counsel did not know it. And when the Court of Appeal learned of this abusive process, because it didn't affect their guilt, they pleaded guilty, they were guilty. The court said, but maybe they would have brought a permanent stay application in this case, and maybe they would have been successful. The fact of the matter is, we have been told a different story by the prosecution. This is not going to happen. They quashed the convictions and they refused there to be a retrial, despite the undoubted guilt of these people. It is one of the instances where courts, and we would very much consider that South African courts would be similar, would say, no. There was a permanent stay application. You told the court that everything that you'd done was of the highest order. There was nothing illegal, there was nothing unlawful, there was no impropriety about it. That was untrue. You knew what you were doing at the time. And you will see what our complaint about the brass mole is. But that is even at a different level. The complaint is, come on, how did you see what was going on in the then Mr. Zuma's, who was then the deputy president, in his attorney's bank account? How did you manage that, Mr. McCarthy? That would have been the first question if he took the stand. Now just explain to us, how did you manage that? Because to the best of our knowledge, you didn't have anything remotely like a warrant at that stage. It is a fundamental principle that you do not mislead the court on such issues.
Yeah, Mr. Kim, I understand the submissions that you are making, but on the facts and circumstances of this case, can you just explain to me, as my colleague said, what was the magic about the 1st of April?
About the 1st?
The 1st of April, 2009. Mr. Mshila was told about the contents of the cassette, and he stated that a decision should be made by the 1st of April. And that decision was made on the 1st of April. Doesn't this affect or has an effect on the rationality of the decision that he took on that day? Why was he in a hurry that the decision should be on the 1st of April?
Well, my lord, as defense counsel, I would say to you, well, if representations were made to him not to continue with the charges, there was a certain timetable in the case. There had to be a permanent stay application that had to be prepared and so on.
And it had not yet been prepared.
Sorry?
The permanent stay application, the papers Have they been served on the...
No.
Not yet?
No.
Yes?
That is one of the reasons why I would submit to you the defense wanted an answer on their representations, because if they were rejected, then that application had to be completed and put before the court, and it would have been a massive thing. Although, I must put to my lord is, if you look at the representations, you will see one theme running through them, and that is we will not have this decided on paper. The Criminal Procedure Act says evidence is viva voce, so we all get into the witness box at that hearing. And you will see that the prosecution team says, no, they will resist that, but so be it. But
when was the application for permanent stay to be served on the NPA in terms of that court order?
My lord is now asking me something that I can't remember off the top of my head. What I'm saying to you
I think
is,
it was sometime in August. Maybe can somebody assist?
I think it was to be heard in August, if I remember correctly, my lord, but I will check it out.
Okay.
But what I'm saying to my lord is, I would think that the defense, and from Mr. Zuma's side, there would probably be also an urgency about, look, I'm going to be inaugurated as a president in a couple of months. We have to know where I stand, if a case goes ahead or not. I would think that for a number of reasons,
but when representations were made, is there any document showing that Mr. Mshila was put on terms to respond by the 1st of April?
No, my lord, I can't recall that. And sorry, I'm saying to you something that's not on the papers.
I think maybe I'll give you more time just to check your papers, as it's almost one.
No, I don't think it's on the paper, certainly. I'm simply saying to you, because that's probably the worst answer that I can give you, that as far as I know, he wasn't put on terms during the representations. But may I say to you, they were urgent. But whether the date had to be the 1st of April, or the 10th of April, or the 15th of April, or the 30th of March, I don't think that was
but
really...
the date was specifically put to the team that it must be at the 1st. I think maybe this will be an appropriate time to adjourn, and we'll continue after.
That may well be so.
Court adjourns.
I haven't seen you today, my friend. What's happening, my friend?